Hello and greetings from SAMVAD. We present to you a three-part series on implementing Section 15 of the Juvenile Justice Act 2015. Through this series, we will be discussing the law on juvenile transfer in India, in particular the implementational aspects of it. This is especially important in light of the Supreme Court decision in the case of Barun Chandra Thakur versus Master Bholu. Through this series, we hope to serve the following objectives. 1. To introduce the juvenile transfer law in India. 2. To explain the NIMHANS preliminary assessment methodology and how the proforma is to be used for children in conflict with the law. And 3. To respond to some frequently asked questions. In the first part of this series, we will be introducing the juvenile transfer law in India. Originating in 19th century America, the idea of juvenile justice entailed separation of juvenile offenders, referred to as children in conflict with law or abbreviated as CICL, from adult offenders. It was founded on the need to provide adolescents with the care and rehabilitation as opposed to detention and punishment. However, in the 1990s, in response to public perception that adolescent and youth offences were increasing and that the juvenile justice system was too lenient, legal reforms designed to deter juvenile offences and get tough on adolescent offenders were passed. One of these reforms, pertaining to juvenile transfer laws, expanded the types of offences and offenders. These reforms lowered the minimum age of criminal responsibility suitable for transfer from the juvenile court to adult criminal court for trial and sentencing. It also extended prosecutorial discretion and curtailed judicial discretion in decisions pertaining to transfer. Such shifts and reforms in juvenile justice are mirrored by countries such as India, which also set up children's courts in the 19th century to ensure complete severance of juvenile and adult systems of justice with a view to preventing children in conflict with the law from being placed in adult prisons and to recognize their needs for care, protection, reformation, and rehabilitation. In fact, this rehabilitative justice ideology was preserved across the years despite the various amendments made to the country's juvenile justice laws.
In 2015, however, this ideology came into question following the incident of gang rape of a young woman in which one of the accused was an adolescent between 16 and 18 years of age. Thereafter, with public pressure on the state to get tough on adolescent and youth offenders, the Juvenile Justice Act was amended, and India joined countries such as the United States of America, United Kingdom, and Canada in adopting juvenile transfer laws in the hope of addressing adolescent offense concerns. And that brings us to the question, what is our notion of justice then, particularly with regard to children in conflict with the law? Does this only encompass establishing whether a child committed the alleged offense and how culpable they are? Do our ideologies of justice extend to understanding it in the context of these children using a multi-layered approach, acknowledging the role of adversity as well as normative adolescent neurodevelopment in their decisions and behavior? And finally, is the dispensation of justice restricted to criminality and conviction, or does it require individual and social reform measures to mitigate social injustice through mental health and rehabilitation interventions?
Due to the difficulty in understanding vulnerable children and their experiences of trauma and adversity, the juvenile justice system tends to focus on the child's aggressive and antisocial actions rather than on the underlying causes of their behavior. The juvenile justice system also ought to focus on rehabilitative measures in accordance with each child's age and developmental level. A meta-analysis of studies on children who stayed within the juvenile system as opposed to children who were transferred to the adult criminal justice system demonstrated that the latter were more likely to recidivate than children who stayed within the system. As noted by the Supreme Court of India in the case of Salil Bali versus the Union of India in 2013, crime statistics provided no policy justification to effect a change to lower the age of criminal responsibility from 18 to 16.
However, there was a growing support for juvenile transfer law, largely based on the public perception that there are increasing rates of violent juvenile crimes in India, and that gave rise to the need for amendments that are retributive in nature under the juvenile justice system. Currently in India, the juvenile transfer law under the Juvenile Justice Act of 2015 stipulates that any child aged 16 to 18 years accused of committing a heinous offence must be subject to a preliminary assessment to ascertain whether the child is to remain within juvenile jurisdiction or whether the child possesses sufficient maturity and understanding in order to be transferred to the adult criminal justice system. Heinous offences is defined by the JJ Act to include offences for which the minimum punishment under the Indian Penal Code or any other law is imprisonment for 7 years or more. This decision to transfer or not to transfer is made by the Juvenile Justice Board after conducting a preliminary assessment of the child. The Juvenile Justice Board conducts the preliminary assessment in order to determine 4 factors pertaining to the child. First, the child's mental capacity to commit such an offence. Second, the child's physical capacity to commit such offence. Third, the child's ability to understand the consequences of the offence. And fourth, the circumstances in which the child allegedly committed the offence. And for the purpose of conducting the preliminary assessment, the board may take the assistance of experienced psychologists or psychosocial workers or other experts. The Act also specifies that the preliminary assessment is not a trial, but it is to assess the capacity of such a child to commit and understand the consequences of the alleged offence.
A major controversy in the dispensation of juvenile justice pertains to the manner of implementation of the juvenile transfer law. One component of implementation relates to the lack of clear guidelines on making transfer decisions. First, it does not define or operationalize various terms contained in the transfer provisions, such as mental capacity, circumstances of the offence, or knowledge of the consequences of the offence, thus leading to varied interpretations of the law itself. This in turn results in the lack of standardized methods of implementation of transfer decisions. Indeed, one of the limitations associated with the process of transfer and sentencing decisions of juvenile court judges globally is the lack of standardization of rules and procedures that direct their decisions. In the absence of a clearly stipulated methodology, legal and judicial personnel who are responsible for transfer decisions also therefore have considerably high discretionary powers in this regard.
In light of these challenges, SAMVAD-NIMHANS developed a proforma to standardize the method in which preliminary assessment could be conducted. SAMVAD conducted deliberations with judicial officers engaged in the dispensation of juvenile justice across the country to understand the challenges they face while conducting preliminary assessments. In 2022, these challenges were discussed by the Supreme Court of India in the case of Barun Chandra Thakur versus Master Bholu, wherein the court also prescribed the SAMVAD-NIMHANS methodology for conducting preliminary assessments across the country. So, let us take a look at what this case was about and what the Supreme Court said.
First, let us briefly take a look at the facts of the case. On the 8th of September 2017, a second standard student referred to as Prince was found dead in an institution in Gurugram. The state transferred the investigation to the CBI, and the CBI interrogated and subsequently arrested a class 11 student from the same institution in relation to the crime. The student, referred to as Master Bholu, was aged 16 years, 5 months and 5 days on the relevant date of the offence being committed. Since Master Bholu The respondent in the case was between ages 16 to 18 and charged with the offence of murder, which is a heinous offence. It was necessary to conduct a preliminary assessment under the ambit of Section 15 of the Juvenile Justice Act. The Juvenile Justice Board called for a report from an expert psychologist, interacted with the respondent, considered the social investigation report and other material placed before it, and proceeded to pass an order holding that there was need of trial of the respondent as an adult and accordingly transferred the child to the Children's Court.
The respondent preferred an appeal before the Children's Court, which subsequently dismissed the appeal. The respondent then preferred a criminal revision petition before the High Court, which set aside the Juvenile Justice Board order and remanded the matter to the board for fresh consideration. The appellant, the Central Bureau of Investigation, and Barun Chandra Thakur filed a special leave petition in front of the Supreme Court against the order of the High Court. However, there was a pendency of over 3.5 years before the respondent's counsel requested for the matter to be taken up by the court, as the respondent was already 21 years of age.
There are a few things here which we need to note as they greatly inform the Supreme Court's final decision. First, the expert psychologist had suggested in his report that further assessment of the child may be carried out at the Institute of Mental Health at Rohtak, which is a tertiary mental health facility. However, the JJB simply ignored this suggestion. Second, the test administered by the psychologist, namely the colored progressive matrices and Malin's intelligence scale for Indian children, were inappropriate as they were meant for children between the ages of 5 and 11.5 and 5 and 15 respectively. The IQ test conducted on the respondent revealed an IQ of 95 at the age of 16 years 8 months, which would translate to a mental age of 15.67 years, yet the child was tried as an adult. Fourth, the CBI admitted in the proceedings before the Juvenile Justice Board that it did not have such officers who were specially trained to undertake such investigation involving children.
Considering the facts of the case, some of the major issues which were considered by the Supreme Court in this case were: 1. Should there be standardization of methodology for conducting preliminary assessments under Section 15 of the Act? 2. What would be considered a reasonable opportunity for the child in a case where a preliminary assessment is to be made by the Juvenile Justice Board under Section 15? To what extent can the child and their guardian or counsel be denied access to the case report, orders, statement of witnesses, and relevant papers under the premise of maintaining confidentiality? 3. Since the proviso to Section 15 states that the JJB may take the assistance of experienced psychologists or psychosocial workers or other experts while conducting preliminary assessment, does this requirement operate in a mandatory form, and will the JJB be obliged to take such assistance?
While analyzing the facts of the case and the arguments made by the counsels, the Supreme Court placed a lot of emphasis on normative adolescent neurodevelopment and psychosocial considerations. The key observations made by the Supreme Court in the verdict of the case on the basis of these considerations are threefold. First, the court opined that the evaluation of mental capacity and ability to understand the consequences of the offence were not a perfunctory and routine task. It requires expertise. Therefore, the term may in the proviso of Section 15 subsection 1 would operate in mandatory form, and the Juvenile Justice Board would be obliged to take the assistance of experienced psychologists and psychosocial workers or other experts while conducting the preliminary assessment. Second, the court opined a great deal on how the principles of natural justice were denied to the respondent. We have already discussed the inadequate and inappropriate tests administered to the child. The court additionally opined that the purpose of confidentiality used in Section 19 of the Act is to prevent the reports from coming in public domain or shared in public. In the interest of natural justice, the child, their counsel, and their guardians cannot be denied access to these reports. Once the legislator's intent is to provide these materials to the victim, then there can never be an intention in the name of confidentiality to deny such access to the records to the child alleged to have come in conflict with the law. Additionally, although the expert psychologist was unsure of their own report and suggested further referral, the Juvenile Justice Board ignored that suggestion. Last but not the least, the Children's Court also has the power to conduct the preliminary assessment under Section 19 of the Act. It would still examine whether the child should be tried as an adult or not. In this case, the Children's Court absolved itself of this duty without conducting an independent assessment and simply upheld the board's order.
The task of preliminary assessment under Section 15 is a delicate task with requirement of expertise and has its own implication as regards the trial of the case. The court was of the opinion that the preliminary assessment conducted in the present case did not take into consideration all four attributes of the child which we had discussed earlier, namely, mental capacity to commit the offense, physical capacity to commit the offense, understanding of the consequences of the offense, and the circumstances under which they committed the offense. The psychologist's report merely assessed the mental capacity of the child, and that too using inappropriate tests that only found out the IQ of the child and nothing more. The court attributed this problem to the lack of standardization of the methodology to conduct preliminary assessment. There was no guidance for the juvenile justice boards on this account, and they were left to their own discretion. Therefore, the court prescribed that SAMVAD-NIMHANS' methodology on conducting preliminary assessments be followed by juvenile justice boards while conducting preliminary assessments under Section 15 of the Act. If you have any questions, you can reach out to us on the email ID provided in the description box. This was a conclusion of Part 1. In Part 2 of this series, we discussed the SAMVAD-NIMHANS methodology for conducting preliminary assessments in greater detail. Thank you. Yes.